Well, good morning. And the first thing that I wanted to say is that I really appreciate the fact that you folks all came out here again this year. There's a lot of places you can spend a Saturday morning doing something other than this, and you folks chose to come out for our conference today, and thank you very much for that. I'm going to stick pretty close to my notes today. I don't make much of an apology for that because Jonathan Edwards used to do that as well. And arguably he preached the greatest sermon that's ever been preached in North America, and he read it word for word. So anyway, I've really struggled over the last year because I've had a full year to consider what to speak about this morning. And for a while, like I say, I really struggled to know what particular subject that I would like to address, because there are so many important issues that we need to discuss as conservative Christians that subject-wise it's kind of a target-rich environment. But then last summer it became very clear to me what I wanted to speak about. This morning I'd like to speak to you about the future of our country, and I'd like to focus upon something that I consider to be one of the greatest problems that we face relative to securing a future for our country. And that problem is judicial tyranny. My hope is that today we can look a bit at the problem, we can reach hopefully a conclusion or two, and then we can discuss what options we might have with respect to action we can take to stop it. Well, in order to illustrate the problem, I'd like to tell a story. It's certainly not the only story that could be told with regard to this problem, but I think it's one that illustrates it very well. It's a story that you, no doubt, are all aware of, but there may be some details here and there that you might not have known. There's a fair amount of detail here, and I hope you won't find this a tedious exercise. Please bear with me, and I think you'll find, as I did, that the relating of all these things together could be rather eye-opening and rather sobering. This is the story of same-sex marriage laws in the United States. Our story begins in 1995 in the state of Utah. While several other states had previously approved statutes defining marriage as between one man and one woman, Utah became the first state to enact a Defense of Marriage Act. A year later, President Clinton signed the Federal Defense of Marriage Act, upholding states' rights to ban same-sex marriage and prohibiting the federal government from recognizing same-sex marriage. In 1998, Alaska approved a constitutional amendment banning same-sex marriage. In 2000, Nebraska voters also approved a constitutional amendment banning same-sex marriage. That same year, California voters approved Proposition 22, which banned same-sex marriage in state law. In 2002, Nevada also approved a constitutional amendment banning same-sex marriage. Then, in 2003, the Massachusetts Supreme Court ruled that the Massachusetts state constitution gives the right to same-sex marriage to gay and lesbian couples. This was the first state to allow same-sex marriages, and those marriages subsequently began in 2004. And that same year, 2004, no doubt in reaction to the Massachusetts ruling, 13 states, Arkansas, Georgia, Kentucky, Louisiana, Michigan, Mississippi, Missouri, Montana, North Dakota, Ohio, Oklahoma, Oregon, Utah, all approved constitutional amendments banning same-sex marriage. The following year, 2005, Kansas and Texas approved constitutional amendments banning same-sex marriage. In 2006, 8 more states approved constitutional amendments banning same-sex marriage. Also in 2006, voters in Arizona rejected a constitutional amendment banning same-sex marriage. And this was the first time such an amendment had been rejected by the voters of any state. Nevertheless, it still passed 2 years later. In 2007, legislation was passed legalizing same-sex marriage in California, but it was vetoed by the Governor Arnold Schwarzenegger. Then, in 2008, the Connecticut Supreme Court ruled that their state constitution gives same-sex couples the right to marry. And that same year, the Supreme Court of California ruled the same way. However, later that same year, voters in California approved Proposition 8, which was a constitutional amendment banning same-sex marriage. Also in 2008, Arizona and Florida approved constitutional amendments banning same-sex marriage. Then in 2009, the illustrious Iowa Supreme Court ruled that the state's constitution guarantees same-sex couples the right to marry, making Iowa the third state to allow gay and lesbian couples to wed. That same year, New Hampshire, Vermont, and the District of Columbia all legalized same-sex marriage through legislation. 1 year later, this puts us at 2010, a federal district court ruled that the Defense of Marriage Act is unconstitutional when it prohibits the federal government from recognizing same-sex marriage. And another federal district court ruled that California Prop 8 was unconstitutional as well. In 2011, Governor Andrew Cuomo of New York signed into law legislation legalizing same-sex marriage. And that made a total at that time of 6 states where it was allowed. In 2012, voters in Maine, Maryland, and Washington state approved laws legalizing same-sex marriage, becoming the first states to do so through popular vote. Voters in Minnesota rejected a constitutional amendment that would have banned same-sex marriage. The same year, voters in North Carolina approved a constitutional amendment banning same-sex marriage. Then the following year, 2013, the United States Supreme Court struck down the Federal Defense of Marriage Act, making the federal government recognize same-sex marriage from all those states where same-sex marriage had been made legal. The court also declined to rule on California Prop 8, taking the position that the defenders of Prop 8 had no legal standing. And the result of that was same-sex marriages began to take place again in California. In 2013 as well, governors in Delaware, Hawaii, Illinois, Minnesota, and Rhode Island signed bills legalizing same-sex marriage. Courts in New Jersey and New Mexico issue rulings that allow same-sex couples to wed. And in 2014, several federal court decisions struck down same-sex marriage bans in a number of states and declined to review cases in Indiana, Utah, Virginia, and Wisconsin. And the effect of this was to require that those states allow same-sex marriage. Additional federal court rulings legalize it in Oregon, Pennsylvania, Colorado, Nevada, Alaska, Idaho, West Virginia, North Carolina, Arizona, Wyoming, Kansas, South Carolina, and Montana. Nevertheless, the Sixth Circuit Court of Appeals became the first and only federal court to uphold same-sex marriage bans, but the ruling only applied to Michigan, Ohio, and Kentucky and Tennessee. Finally, on June 26th of this year, the United States Supreme Court ruled all state bans on same-sex marriage to be unconstitutional, thus allowing gay and lesbian couples to marry in all 50 states. Well, there's a couple of observations about this story that are in order. First, as you could not have missed, in the majority of the states where same-sex marriage was legalized, the issue was decided not by the American people, but by the courts. Secondly, as of 2003, the vast majority of the states had legislative bans on same-sex marriage. And by 2007, many of those same states had in addition passed an amendment to their state constitutions banning same-sex marriage. 29 states eventually did that. And on top of all that, of course, there was also the Federal Defense of Marriage Act. In short, all of these states had done all that was in their power to ban same-sex marriage. And remember this, short of an amendment to the United States Constitution, even the legislative and executive branches of the federal government had attempted to protect the traditional understanding of marriage. So what are we to make of all this? You are probably familiar with the famous quote by Thomas Jefferson in which he responds to the landmark ruling by the United States Supreme Court in Marbury versus Madison. Quote, "You seem to consider the judges as the ultimate arbiters of all constitutional questions, a very dangerous doctrine indeed, and one which would place us under the despotism of an oligarchy. Our judges are as honest as other men, and not more so. They have with others the same passions for party, for power, and the privilege of their core. Their power is the more dangerous as they are in office for life, and they're not responsible, as the other functionaries are, to be under elective control. The Constitution has erected no such single tribunal, knowing that to whatever hands confided with the corruptions of time and party, its members would become despots," unquote. Well, this didn't happen overnight, and it didn't happen as quickly as probably Jefferson may have feared that it would. But there's little doubt in my mind that we find ourselves now in exactly the place that Jefferson described. We are indeed under the despotism of an oligarchy. Now, of course, the question is, do we have other problems with regard to our governance besides merely that of the judiciary? And the answer to that is, of course. We've got a president and a Congress that have done us much harm, and there is no denying of that. But I would contend that on the issues that matter the most to the people in this room, it is the courts that have done us far more damage than our elected officials. And the courts are fully aware of the power that they have. The best example that I can give of that, and you've no doubt heard about this as well, this is a well-known anecdote, but the best example is the rule of 5 that Justice Brennan famously used to teach his new law clerks. Brennan would ask them what the most important rule they needed to know when they were going to work in his chambers. He would ask them that question, and when giving them the answer, he would hold up his hand with his fingers spread wide apart. And he would say, "This is the most important rule in constitutional law. The law of 5. With 5 votes, you can do anything around here." Well, let's consider that for a moment, because Brennan was right. In the Obergefell versus Hodges case decided last summer, 5 people in black robes decided, as a legal matter, not as a theological one, but as a legal matter in the United States, that marriage was no longer going to be understood as be between one man and one woman. 5 people decided this. Once again, I'm speaking merely as a legal matter. 5 people decided this for nearly 320 million of us. Justice Antonin Scalia said this in his dissenting opinion regarding Obergefell versus Hodges. Quote, "The opinion in these cases is the furthest extension in fact, and the furthest extension one can even imagine, of the court's claimed power to create liberties that the Constitution and its amendments neglect to mention. This practice of constitutional revision by an unelected committee of 9, always accompanied, as it is today, by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, and that is the freedom to govern themselves. Once again, a court has done the unthinkable, and the unthinkable has now become mere routine. The U.S. Supreme Court in particular has once again done something that will have unfathomable consequences on our nation. You all know that in 1973, of course, they imagined that the Due Process Clause of the 14th Amendment included a right to privacy that extended to the killing of one's unborn child. At that time, in a lament similar to Scalia's dissent in Obergefell, Justices Byron White and William Rehnquist pointed out the court's creation of a new constitutional right. Justice White said this, quote, "I find nothing in the language or history of the Constitution to support the court's judgment. The court simply fashions and announces a new constitutional right for pregnant women, and with scarcely any reason or authority for its action, invests that right with sufficient substance to override most existing state abortion statutes." Unquote. He went on to say this, "As an exercise of raw judicial power, the court perhaps has the authority to do what it does today. But in my view, its judgment is an improvident and extravagant exercise of the power of judicial review that the Constitution extends to this court." Unquote. Justice Rehnquist, for his part, said this, quote, "To reach its result, the court necessarily has had to find within the scope of the 14th Amendment a right that was apparently completely unknown to the drafters of the amendment." Unquote. While I do not believe that the voice of the people is the voice of God, I can tell you this. In Obergefell, the vox populi was crushed by the courts. And in both Obergefell and Roe, the vox dei was completely ignored. And we have to ask ourselves, what meaningful protection does the Free Exercise Clause of the First Amendment give us anymore? Let's ask the Christian bakers, the Christian florists, the Christian bed and breakfast owners that question. Let's ask Dick and Betty Odgaard, who used to own the Gertz House in Grimes, Iowa, that very question. What protections did they receive? So what are we to do? I believe that one of our foremost objectives must be to stop a runaway judiciary and the tyranny that goes with it. And with all due respect to our representatives in Congress, I believe we cannot rely on them to do anything about it, regardless of who we elect. I believe that we must call an Article 5 Convention of States and put a stop to this tyranny while we still have a country left to save. All we need are 34 states to submit applications for an Article 5 convention. These applications must deal all with the same issue. Now, here are just a few of the things that could be done through this process. We could mandate term limits for the Supreme Court justices. We could change the appointment process so that the Supreme Court appointments would be made by the states. We could allow Supreme Court decisions to be vacated by a supermajority of either the states or the Congress. We could mandate originalism as the only allowable judicial interpretation for Supreme Court justices under penalty of impeachment. And here's the real beauty of all this. Congress can't stop it. They can't block it. They are obliged to call it. Neither can our illustrious president with his phone and his pen. I know that many of you may be thinking that even if we could accomplish this, we run the risk of a, quote, runaway convention, unquote. And you may view that as an unacceptable risk. I have two responses to that concern. First, from what I can tell, the idea of a runaway convention of states is more or less a scary myth, kind of like climate change. Ratification of any proposed amendment requires the approval of 38 states. Only 13 states are required to say no to defeat a proposed amendment. So the likelihood of a rogue amendment getting approved is essentially non-existent. Second, I believe with all my heart that even if such a risk was real, we should take that risk anyway. You see, I believe and suspect many of you do too, that if we don't take some dramatic action and take it soon, we won't recognize our country in another 10 years. There may still be a nation known as the United States of America, but it will not be the nation that we grew up in and the nation that we love. And so I say again, I believe we must call an Article 5 Convention of the States. I believe this is our first and best option to put an end not only to judicial tyranny, but to all kinds of abuse and overreach by the federal government. We have other options, of course, but none of them are particularly pleasant. Perhaps some of you are sympathetic to the notion of nullification of federal law by the states, and I would simply ask you to join with us to work for a convention of states first before moving to attempt nullification. Look, we know two things. We know that the theory of nullification has never been legally upheld by the federal courts, but we do know that there's no debate about the legality of an Article 5 Convention of the States. As Christians, we of course have great concerns about our various duties with respect to Romans 13. Christians have been divided on aspects of this subject for centuries. But I know of very few Christians who would object to pursuing a convention of states on any grounds related to Romans 13. We should be able to unite and work together for this endeavor. Allow me once again to quote Justice Scalia. He made these remarks at Santa Clara University just last Wednesday. For Pete's sake, the Constitution is a legal document. It means what it says, and it doesn't mean what it doesn't say. People don't say anymore, it's unconstitutional. Instead, anything you hate should be prohibited, and anything you love should be supported by the Constitution. I don't know where this comes from. He went on to say that the Supreme Court's movement toward what he called the living Constitution started in the 1920s and began with essentially non-controversial rights, but eventually headed down a slippery slope. He said, at the bottom of that slope, I can't imagine how you can go any further, is the right to same-sex marriage, unquote. I say, indeed, Justice Scalia. Finally, he said this, do you think the American people would have ever ratified the Constitution if they'd been told that the meaning of this document shall be whatever a majority of the Supreme Court says that it is? He added this, it's the destruction of our democratic system. I cannot imagine the system can continue with more and more of the basic rules made by the Supreme Court, unquote. I believe the first and best remedy to what Justice Scalia has pointed to here is an Article 5 Convention of the States. And the expert on that very issue is with us today. So I'm not going to take any questions. Looks to me like I've run out of time anyway. I'm just a guy who lives literally a few yards from a cornfield. But Michael Ferris is here, and I would encourage you to give consideration to whatever he has to say about the Convention of States. And let us join together in that endeavor. And I would be remiss if I failed to acknowledge that all of our attempts to do anything will, of course, be all for naught if God is not pleased to give us his smiling providence in this connection. No doubt our greatest efforts must be those in which we are on our knees in prayer. May God protect the Church of the Lord Jesus Christ, and may God bless America. And thanks for bearing with me.